arguing that the mosque surveys are illegal. They reek of retributive justice. That's what they're saying. That there is a bar imposed by Section 3 of the Places of Worship Act 1991 on the institution of fresh suits or legal proceedings. Now, how do you react to this, sai Deepak?
It's not called retributive justice, it's called reparative justice. Retribution is in the mind of the victim or the perceived victim. Reparation is from the perspective of the actual victim. Okay? Now let's start with the clarity on the law or the legal position itself. The Places of Worship Act does not, by any stretch of imagination, either through its black letter or in spirit, come in the way of any of the surveys that are being undertaken with respect to these occupied sites. Point number one. Two, it's easy to simply confound or confuse the general public by citing Section 3 of the Places of Worship Act without drawing attention to Section 4, subsection 3 of the very same piece of legislation that specifically says if you manage to establish that an underlying structure is an archaeological site or a heritage structure, which if you go back to the 1958 Act, which is the Archaeological Act of 1958, it becomes abundantly clear that anything that is beyond 100 years or over 100 years specifically constitutes for treatment or qualifies for treatment as a heritage structure. Once that is established, the Act makes it abundantly clear, that is the Places of Worship Act makes it abundantly clear, that the fetters imposed by the Act or the bar imposed by the Act with respect to character conversion of a particular place, they don't apply. None of the provisions apply. Okay? So as far as I'm concerned, any such statement that is being made, I would say is a legally unlettered submission. Unfortunately so, if it's being made by anyone who's trained in the law. So legally, I don't see a problem. Two, why should this lead to the conclusion that this is retributive justice? When the world over, every civilization and country which respects itself has brought in its right of return or has invoked its right of return to specifically take back its occupied sites, which it believes represent or represents the native culture or the indigenous culture of the land. So the reason or the backdrop for this entire conversation happens to be the motivated violence in Sambhal. If a particular party or a particular group chooses to stand in the way of the law and decides to pick up the weapon in response to a court-initiated procedure, and that too in resistance to a court-appointed committee for the sake of verification, who is coming in the way of the law, who is standing in the way of the rule of law prevailing, and why should such parties be indulged and incentivized through cloaks of perceived victimhood? That's the simple question that you should be asking. Why can't we actually ask for a position where the Indian state says no one will take law in their own hands and ultimately let matters be decided on the basis of evidence by a court of law? That's perhaps the most constitutional position, that's perhaps the most non-confrontational position that anybody can take.
There is a view that the mosque survey is against the spirit of the Supreme Court order in Ayodhya judgment that said, quote, the state has, by enacting the law, enforced a constitutional commitment and operationalized its constitutional obligation to uphold the equality of all religion and secularism, which is a part of the basic features of the Constitution, unquote. And this is why many people say that because it was mentioned, we shouldn't have all these surveys. Your response?
So there is a problem with the reliance on this particular portion of the Ayodhya judgment. I have written extensively on this, so let me quote from my own articles on the subject. One, the 10-paragraph discussion that was undertaken in the Ayodhya judgment on the Places of Worship Act is superfluous to that entire judgment because the Places of Worship Act was never an issue in the Ayodhya case. What is the meaning of this? Section 5 of the Places of Worship Act specifically says that no provision of the Places of Worship Act shall apply to the Ram Janmabhoomi dispute, which means the statute is inapplicable to the dispute. When a statute is inapplicable to a dispute at hand, any discussion on the statute in a judgment on that particular dispute doesn't constitute the central reasoning of the judgment. It constitutes what we call obiter dicta, which means side observations, marginal observations. First of all, therefore, they have no binding at all, or in the sense they have no binding value or precedential value. Because the law as laid down by the Supreme Court is only the finding of a court on an issue in question and which is relevant to the dispute at hand will have some value for future cases. Since Places of Worship Act was fundamentally irrelevant to the discussion on Ayodhya, there is no question of it having any binding value subsequently. Two, no discussion was undertaken in the Ayodhya verdict on the impact of section 4.3 and its interplay with section 3 or section 6 or section 4.1. Okay, the first time that this issue is being taken up is as part of the batch of petitions filed before the Supreme Court on the challenge to the Places of Worship Act, where some of us have taken the position, and Vishnu has already taken this position, Mr. Shivshankar Jain, in the Kashi case and other cases, that the survey is not barred by the Places of Worship Act. And the very same Supreme Court, when the orders of the district court in the Kashi case were challenged before the Supreme Court on the ground that the suit itself was not maintainable because of the Places of Worship Act, said that it's for the trial court to take a decision. Even the Supreme Court did not press into service the Ayodhya verdict to say that these suits are unmaintainable. And if the fundamental basis of the suit is a survey, then the survey is kosher, the suit is kosher, and the reliefs are kosher.
Well, your own contemporary, another senior advocate of the Supreme Court, Mr. Dushyant Dave, has written that the mosque surveys are being ordered despite the Supreme Court setting aside findings of the Justice Sharma of the Allahabad High Court that ruled that the Places of Worship Act in 1991 does not debar those cases where the declaration is sought for a period prior to the act came into force, unquote. Now, isn't this therefore reason enough to stop these surveys?
Not at all. And I'll answer this question. And I wish the gentleman or the person who's written the piece had actually bothered to go through the judgment of the Supreme Court in the Ayodhya case. I went through the Allahabad High Court judgment, the 3 volumes, as well as the Supreme Court judgment, where the Supreme Court cites Justice Sharma's reason, or let's say cites Justice Sharma's analysis to venture into a discussion on the Places of Worship Act. If you remember, Rahul, you and I have already had a discussion on this particular issue, so let me refresh your memory as well as the audience's memory on the subject. Justice Sharma in the Allahabad High Court was not discussing the Places of Worship Act. Justice Sharma was citing another Supreme Court judgment of 1995 where this discussion had taken place, and he was quoting it in a different context altogether. When the judgment of the Allahabad High Court goes up in appeal before the Supreme Court commits an error. That is, the Constitutional Bench of the Supreme Court committed an error in mistaking Justice Sharma's extraction of a previous judgment as Justice Sharma's opinion itself. And then it embarks on a discussion on the Places of Worship Act for 10 paragraphs. So there is an article that I wrote on this very subject on two different platforms. The New Indian Express, I wrote this as soon as the verdict came out of the Supreme Court. Then I've also written this in the Open magazine, explaining this issue in greater detail. Plus on my blog, it's a 2-part article which I've written on my blog called Yukti, which is a constitutional law blog, where in detail I've captured this entire thing. Therefore, there is no applicability of the Ayodhya verdict to this particular case. The discussion in the Ayodhya verdict on the Places of Worship Act was both factually erroneous and legally irrelevant.
So are you referring to the 1995 Supreme Court judgment that involves a dispute between 2 churches? Can you elaborate on this?
So, basically, one of the questions that was being asked, I think in the 1995 case, was whether religious disputes can be contested in suits of civil nature, or do you need only writ petitions? One of the answers that was given to the best of my memory was that a right under Article 25 is equally capable of being contested through a suit. That's one. Second, the question of character of conversion of a Christian place and the cutoff date as prescribed in the Places of Worship Act was the subject of the discussion of the Supreme Court verdict in 1995. Now, remember, the Ram Janmabhoomi dispute has no, let's say, discussion with respect to the Places of Worship Act in the entire three-volume judgment of the Allahabad High Court of the three judges, because that the entire legislation is inapplicable to the act. So why would they discuss something which is not even relevant to it? So during the course of a discussion on the nature of a civil suit and whether religious rights and constitutional rights can be contested through civil suits, a particular paragraph from the Marthoma judgment, from the Supreme Court judgment of 95, is extracted. That discussion is mistakenly assumed by the Constitution Bench of the Supreme Court in the Ayodhya dispute as a discussion on the Places of Worship Act by Justice R.S. Sharma. Frankly, it is a clear case of clerical error where the Constitution Bench of the Supreme Court misunderstood the entire context of the discussion.
Now, just to clarify, has the Supreme Court overruled the verdict of the Supreme Court Justice R.M. Sahai, who ruled in the most revered PMO Metropolitan and others versus Moranmar Morthoma and another on June 1995, that, quote, Act doesn't debar those cases where declaration is sought for a period prior to the Act before it came into force for the enforcement of a right which has been recognized before coming into the force of the Act. So how did Justice Bodbode and Chandrachud greenlight these surveys, sir? Please clarify.
One, this was an error. And second, since the Places of Worship Act was never the direct subject of dispute in the Ayodhya verdict, whether or not a survey could be ordered under the auspices of the Places of Worship Act or outside of it was never in contestation there. Therefore, when that issue comes up for a standalone examination in Kashi, Mathura, and now Sambhal, then everybody is suddenly looking at Section 4, subsection 3. And those who are citing the Places of Worship Act to prevent these surveys selectively cite only Section 3 or Section 4.1 without drawing the attention of the audience or the court to Section 4, subsection 3. Which is why when Justice Chandrachud and subsequent benches were presiding over the appellate proceedings or the interim appellate proceedings that emanated from Kashi or Mathura, they specifically said whether or not these suits are barred by the Places of Worship Act. Firstly, that call has to be taken by the trial court first, because the Supreme Court cannot venture into an examination of an issue when the trial court is still considering it. Two, if they truly felt that this was so egregious an issue, because the Ayodhya judgment has already closed the door on this particular subject, they would have said as much. But they know for a fact that that was not the situation. So what I would suggest is, you take up, you can perhaps ask your viewers to simply Google Ayodhya verdict and the Places of Worship Act. You will find a New Indian Express article written by me on 3rd of June 2020, where I specifically discussed this verdict and whether there was any impact of the Places of Worship Act or the Ayodhya judgment on each other. Can I just read maybe 5 lines from that particular article? Can
Please
I just
go
do
ahead.
that with your...
No, please go ahead. Please go ahead.
So in paragraph 80, the Supreme Court in the Ayodhya verdict specifically says that Section 5 of the Places of Worship Act expressly exempts the legal proceedings in relation to Ram Janmabhoomi from the application of the Places of Worship Act. So the Supreme Court itself said in paragraph 80 that the Places of Worship Act was irrelevant to the dispute. Therefore, it had no reason to subsequently proceed to discuss it further. So, which is why I said, in light of this, there was no need for the court to discuss the act in the context of Sri Ram Janmabhoomi. And yet the court deemed it fit to discuss it in over 10 pages, with the central thrust of its deliberation being the Constitution's commitment to secularism. The stated reason for this discussion is captured in the said paragraph. The court reproduced what it believed were the observations of Justice D.V. Sharma, who was part of the majority opinion of the Allahabad High Court. Extracted below are, within quotes, the observations of the Places of Worship Act, of Justice Sharma, that ostensibly triggered the Supreme Court's discussion on the Places of Worship Act. So there is one paragraph 1C, which is captured in the judgment of the Allahabad High Court. If you realize, and if you read it further, there is no such paragraph of Justice Sharma itself, because he is quoting another judgment of the Supreme Court, which you just pointed out, which is PMA Metropolitan and Moranmar Thoma and another, delivered in 1995. And what did Justice Sharma do? he extracted paragraphs 43 and 89(1)(c) of the Marthoma judgment in his judgment, which the Supreme Court mistakes as paragraph 1(c) of Justice Sharma's observations.
Oh.
Anybody, if they had just bothered to go through the original Supreme Court judgment of 95 and then the Allahabad High Court judgment, they would wonder, how did the Supreme Court make such a basic error in conflating two different judgments?
Well, I'm glad that we've addressed this issue, because those who are looking at the fine print, viewers, and the fine points will have gone into this, and I'm glad that sai Deepak has set that to rest now. But let me just ask you, finally, aside from the letter of the law, I would like you to respond to a specific charge made by the same lawyer, Mr. Dave, and he says, and I quote, Chief Justices of India, Bodhbe and Chandrachud, presided over benches with other learned judges that undermined the court's previous ruling and cleared the ground for a dangerous situation, unquote. Now, sai Deepak, this criticism is in line with many who feel that the judiciary has turned saffron today. Your response to this?
Frankly speaking, nobody had a problem as long as judgments were being delivered in favor of a particular minority group. But when a non-minority group manages to establish its case on the strength of the law within the four corners of the Constitution, suddenly the entire institution is being painted as having turned saffron. In which case, I must ask myself the simple question, does this clique believe that the majority should not have any access to any kind of reparative justice remedies before the Supreme Court, and that too through a legal process? Nobody has been able to actually point a finger to the legality of the process or at the legality of the process through cogent arguments. Everything is based on misrepresentation. So I must clearly say here that the Supreme Court has acted in accordance with the Constitution by upholding the letter of the law and the spirit of the law. And secondly, if somebody has to focus extensively on the spirit of the law, that means they admit that the letter of the law certainly does not support their position. That's when they resort to all sorts of vague arguments. I am giving a very clear response on the basis of the express language of the Places of Worship Act, express language of the Ayodhya verdict of the Allahabad High Court as well as the Supreme Court, and the 1995 verdict of the Supreme Court in the Marthoma Church case. Can someone counter this and tell me that factually and legally this is wrong? I will happily debate them in public, word by word, para by para, on these very assumptions.
Well, sai Deepak, thank you very much. As always, exacting and brilliant. Thank you very much for going into the details, viewers. I know it was a bit